Generally, publicly held and closely held corporations may have stock transfer restrictions in their articles of incorporation, bylaws, or agreements with shareholders. Such restrictions don't affect ownership of a shareholder's stock, but instead qualify a shareholder's right to dispose of his or her stock. In the 1986 case, Frandsen v. Jensen-Sundquist Agency, the United States Court of Appeals for the Seventh Circuit considered whether a proposed merger agreement constituted an offer to sell stock, thereby triggering stock transfer restrictions. Jensen-Sundquist Agency was a holding company that was owned by Walter Jensen. In addition, Jensen-Sundquist's principal asset was a majority of stock in the First Bank of Grantsburg. In 1975, Jensen sold 52% of ownership in Jensen-Sundquist to his family members, which we'll refer to here as the majority block, 8% to a businessman named Dennis Frandsen, and the rest to non-family members. Pursuant to a shareholder agreement entered into by the parties, if the majority block decided to sell its shares, it had to give Frandsen a right to buy the shares at offer price. In addition, pursuant to the agreement, if Frandsen declined, the majority block had to offer to buy his shares at the same price at which it sold its own shares. In 1984, First Wisconsin Corporation, Wisconsin's largest bank holding company, sought to acquire Jensen-Sundquist stock in the First Bank of Grantsburg. The parties reached a proposed merger agreement where Jensen-Sundquist would merge into First Wisconsin. The majority block then asked Frandsen and the non-family members to sign a waiver of rights in the transaction. The non-family members signed the waiver, but Frandsen refused and sought to exercise his right of first refusal to buy the majority block's shares under the shareholder agreement. The majority block refused to sell Frandsen its shares, and eventually Jensen-Sundquist sold its stock in the First Bank of Grantsburg to First Wisconsin and liquidated. Subsequently, Frandsen sued Jensen-Sundquist in the United States District Court for the Western District of Wisconsin for breach of the shareholder agreement. In response, Jensen-Sundquist moved for summary judgment, arguing that the stock transfer restriction in the shareholder agreement, giving Frandsen right of first refusal, wasn't triggered by the proposal to merge Jensen-Sundquist into First Wisconsin. The district court agreed and granted the motion. Frandsen appealed to the Seventh Circuit.